Please be seated. The court is now back in session, and the chamber will hand the floor again to Nuon Chia's defense to continue presenting their closing statements. You may proceed. Sanarun. Once again, good afternoon, Mr. President, Journalists, and everyone. Today I will present two main topics. One is the first movement of population, and the second one is the second population movement. Now I touch upon the first population movement, and I will turn to the evacuation of Phnom Penh. As the chamber knows, Nuon Chia does not deny his participation in the decision to evacuate Phnom Penh. He readily concedes that he knew about it, agreed to it, and approved of it. As I will demonstrate, Nuon Chia is nevertheless not guilty of any of the crimes charged in connection with the evacuation. My analysis of the evacuation of Phnom Penh will proceed in two general parts. First, I will discuss the CPK's decision to evacuate Phnom Penh. I will explain to the chamber the rationale for that decision, and I will show that the evacuation was lawful under all of the circumstances. In other words, I will be addressing the allegation that the evacuation of Phnom Penh was itself a crime against humanity. Second, I will address the allegation that Nuon Chia is guilty of a variety of crimes committed during the evacuation. These crimes are alleged to follow from the use of violence by CPK troops and the conditions imposed on the evacuees during the course of the evacuation. Let me begin with the first general issue, that is the legality of the evacuation itself. On last Thursday morning, the co-prosecutors claimed that Nuon Chia has justified the evacuation on two grounds. According to the co-prosecutors, Nuon Chia's first justification for the evacuation was to implement an economic policy that he believed was in the best interest of the Cambodian people. According to the co-prosecutors, Nuon Chia's second justification is that the evacuation was necessary, quote, in light of the dire humanitarian conditions in Cambodia in April 1975, end quote. The co-prosecutor's description of the CPK's first reason for the evacuation was more or less accurate. As my colleague Victor Coupe observed on Tuesday, the co-prosecutors claim to be surprised at Nuon Chia's assertion that the evacuation was primarily an effort to reform economic structures in Cambodia. They claim not to understand why Nuon Chia has not previously said this to the chamber. To begin with, the co-prosecutors appear to fundamentally misunderstand how a criminal trial is supposed to work. Nuon Chia is not required to explain why he did anything. The co-prosecutors are required to carry their burden to prove, beyond a reasonable doubt, that Nuon Chia intentionally committed criminal acts. Key to understanding the reasoning behind the evacuation are pre-1975 conditions. I am not going to go into these in detail. We have discussed them and plead them previously before the chamber. We have, in any event, very little new evidence to present as a consequence of this chamber's persistent refusal to call key context-related witnesses. To briefly summarize key points, however, the CPK took power in 1975, facing a dire economic predicament. The country's rice paddies, its economic engine, had been subject to widespread destruction. Its rice production capacity had been devastated relative to pre-1970 levels. Roads and railways were destroyed, and farmers were idle in the cities instead of tending to their farms. Cambodia was and always had been a peasant agricultural society. A number of the paddy fields had been destroyed by the bombardment. Agriculture was the source of its economic production, and it was rooted in the countryside. Under these circumstances, the CPK determined that Cambodia was incapable of supporting urban centers, which produced nothing and at the same time maintained social and economic structures which perpetuated inequality. That conclusion was, of course, deeply connected to the CPK's political ideology and its ideas about preferred modes of production. As we have argued in the past, it is impossible to view the evacuation as an isolated event. The CPK's plan did not end at the evacuee's destination. The CPK's plan to evacuate Phnom Penh was part and parcel of their effort to establish agricultural cooperatives as the basic unit of the Cambodian economy. There is no real or serious question about this. Despite their protest, the co-prosecutors do not actually contest this. As we will see momentarily, what they actually contest is Nuon Chia's motives. Instead of considering what cooperatives meant to the CPK in terms of politics or economics, they prefer to dismiss it simplistically as enslavement. In 1975, involuntary population movements were regularly supported by reputable international organizations such as the World Bank and even the United Nations. The most vivid example concerns dammed constructions, which often displaced tens of thousands of hundreds of thousands of people in affected areas. These projects were seen as acceptable because their objectives, that is to generate electricity, were more consistent with the common narrative of progress than those of the CPK. Not until 1980 did the World Bank even have a policy toward internal resettlement as a consequence of bank finance projects, which means that prior to 1980, involuntary displacement was not even a consideration in the bank's decision-making process. Even after 1980, involuntary displacement was a common feature of World Bank projects. In Africa, between 1981 and 1994, the World Bank supported large-scale development projects, causing involuntary internal displacement in 38 countries. Altogether, between 1955 and 1990, tens of millions of people across India, China, and Africa were forcibly displaced as a consequence of dam, mine, and industrial construction, urbanization, and other causes. Even the United Nations, which founded this tribunal, has recognized the benefits of land resettlement, quote, to raise national or individual incomes, or to increase agricultural employment or production, end quote. The co-prosecutors choose not to engage at all in this discussion. They choose not to consider whether the evacuation might have been lawful in light of the overwhelming state practice approving of involuntary displacement under a wide variety of circumstances. The co-prosecutors instead insist that the evacuation of Phnom Penh and the establishment of cooperatives could not have been part of a legitimate economic program because of, and I quote, the manner in which the cooperatives actually operated, end quote. Given the history of this trial, this is a shocking claim to come from the co-prosecutors at this stage of the proceedings. As the co-prosecutors well know, when this chamber determined the scope of the case 002/01 trial in February 2013, the Nuon Chea defense argued that It was impossible to adjudicate the evacuation of Phnom Penh without a full assessment of the policy and implementation of cooperatives. We argued that, and I quote, in April 1975, Nuon Chea had good reason to believe that cooperatives were effective methods of food production and distribution, and they proved as such in many parts of Cambodia. Nuon Chea cannot articulate a coherent defense to forced transfer without a detailed assessment of that which was supposed to and did follow the evacuation. End quote. The co-prosecutors successfully opposed our request to add cooperatives to the scope of this trial. Accordingly, they prevented any substantive consideration of how cooperatives actually worked. And now, 7 months later, they come before this chamber and tell Your Honors that you should reject Nuon Chea's claim that the evacuation was part of a legitimate economic program because of the way that cooperatives actually worked. The hypocrisy is apparent. The chamber should reject this position outright. Having chosen to exclude this question from the scope of this trial, the chamber must not base any conclusions about the legality of the evacuation on the co-prosecutors' unsubstantiated opinions of what actually took place in the cooperatives. The co-prosecutor's co-allegation about the evacuation is that it was a, quote, inherently punitive act, end of quote, against the population of Phnom Penh. That the CPK was trying not to reform policy and implement a revolution, but to conduct itself violently and maliciously for no apparent purpose, like the slave state. This is another of the co-prosecutors' attempts to reposition the CPK as a criminal entity. To strip it of its political objectives, to infuse the CPK with criminal intent, to create a simplistic shortcut around the difficult and complicated question whether Nuon Chea intended to commit the criminal acts with which he is charged. It is inconsistent with every shred of the evidence, which repeatedly links the evacuation, the formation of cooperatives, and the reconstruction of the Cambodian economy in one cohesive economic policy. Critical to the co-prosecutor's effort to persuade the chamber that the evacuation of Phnom Penh was a, end quote, punitive act, end quote, is their position that the inhabitants of the city were seen as enemies or potential enemies of the party. In support of that claim, they rely on a long line of quotes from secondary sources. We object again to the use of this kind of evidence from foreign academics who were not present in Cambodia during democratic Kampuchea. The use of these sources is especially troubling in light of the purpose to which they are being put, to tell the Chamber the intent of CPK policy, to tell the Chamber what was in Nunji's mind. These people cannot possibly know what was in Nunji's mind. The reality is that during the war, Phnom Penh was seen as a stronghold of the enemy in which everyday people lived. The everyday people not themselves at any time considered to be the enemy of the party. It appears likely that the co-prosecutors are acutely aware of their failure to find any witness with real knowledge of CPK policy towards city dwellers to support their position. We say this because of their remarkable decision last Thursday to rely on the testimony of Chuk Ren. Chuk Ren was a long-time CPK soldier who appeared before this chamber. He made this distinction between wartime opponents and the civilian population starkly. He clearly explained that the population of Phnom Penh was never understood to be an enemy of the party. Chuk Ren's testimony in that regard came despite the co-prosecutors' repeated efforts My apology, allow me to repeat this. Chuk Ren's testimony in that regard came despite the co-prosecutors' repeated efforts to coerce him into testifying otherwise. In the course of his testimony, Chuk agreed to testimony from his OCIJ statement that prior to 1975, city dwellers were understood to be, and I quote, with the, end of quote, enemy. In a deliberate effort to misconstrue their testimony, the co-prosecutors asked, and I quote, "When was it then that people were speaking to you about the 17 April people being enemies?" End quote. Chuk was not misled and confirmed twice that he, and I quote, never received any instructions that the 17 April people being considered enemies, end of quote. The next day, Chuk Ren continued to testify. The co-prosecutors tried again to misrepresent the substance of his prior day's testimony. They tried to trick the witness. They suggested to him, and I quote, "You said yesterday that even a baby would have known in 1973 that city dwellers were the enemy," end quote. Yet, Chuk stood firm, correcting the prosecution for a third time. He testified as follows, and I quote, "We never treated anyone including a baby, as an enemy. Because we hate to liberate the cities, and we never wage war with the civilians. Indeed, we treated other opponents like the soldiers of the other party opposing us as our enemies, but we never treated civilians as our enemies. End quote. Your Honors, let me emphasize this again. This unequivocal testimony that CPK troops never treated civilians within the cities as their enemies, which Chukran repeated 3 times, despite the co-prosecutors' continued and willful efforts to mislead him into testifying otherwise, is what the prosecution tells us that it establishes CPK attitudes toward city dwellers. Even more important than the fact that the prosecution relied on this evidence is the fact that the prosecution relied only on this evidence. Other than Chukran, their unequivocally false claim that city dwellers were seen as the enemy or as inherently suspect is supported only by references to secondary sources. Primarily, once more and yet again, Philip Short. In addition to the evidence which the co-prosecutors themselves cite, the notion that city dwellers were the enemy of the party is refuted by a veritable stockpile of evidence. The October 1975 issue of Revolutionary Youth describes the efforts of the cooperatives to feed and support more than 2 million people who have just been liberated from the rule of the contemptible traitors. Evacuees from Phnom Penh who gave evidence before this tribunal testified repeatedly that they were provided food and shelter by base people upon arrival at their destinations. They testified that they were treated well and the same as base people. That evidence, which is assembled at paragraph 280 of our brief, includes the live testimony and OCIJ statements of no fewer than 11 witnesses. That evidence is furthermore mirrored by the evidence of CPK insiders who said that they were instructed to prepare for the evacuees' arrival and to ensure they were taken care of. Non Soon told Steve Heder that he was instructed to prepare food, water and lodging for arriving evacuees. Uk Bun Chun told Steve Heder that efforts began as early as February 1975 to prepare housings in cooperatives at the base.
This evidence is further corroborated by the numerous CPK publications which repeatedly instruct cadres to respect classes of people closely associated with city dwellers. The September 1974 issue of Revolutionary Youth states that the petty bourgeoisie, intellectuals, and students are allies of the peasant workers and, I quote, love revolution, unquote. The September 1977 issue of a Revolutionary Flag states, I quote, the petty bourgeoisie, the pupils, students, and intellectuals of every kind are allies of the workers and peasants, and it was the same in the past, and it is still the same today in the status of their original class, unquote. The co-prosecutor's description of Nuon Chia's second reason for the evacuation was that it was, quote, necessary in light of the dire humanitarian conditions in Cambodia in April 1975, unquote. The co-prosecutor proffered evidence that the CPK launched rockets and blocked supply lines into Phnom Penh. They seek to persuade the chamber that because the CPK's conduct in the months prior to the liberation of Phnom Penh shows that their motives were not, quote, humanitarian, unquote. Nuon Chia's explanation for the evacuation must be dishonest. Yet, the following sentence appears at paragraph 254 of our final trial brief. I quote, never once has Nuon Chia claimed that the evacuation of Phnom Penh was a humanitarian act, unquote. Nuon Chia was not the Deputy Secretary of the Red Cross. He was the Deputy Secretary of the Communist Party of Cambodia. He was fighting a revolutionary war. He is not required to prove that he was a humanitarian in order to justify his policies. The only relevant question is whether under the totality of the circumstances, the decision to evacuate Phnom Penh constituted a crime against humanity. It is the fact that when the CPK liberated Phnom Penh, there was a severe and nearly catastrophic shortage of food, fuel, and other necessities. The prosecution claims that this crisis was caused by the CPK itself, yet the evidence cited in our brief shows that it began in 1972 and escalated severely through 1973 as the American bombing progressed. Sources dated from 1973 described the crisis, establishing beyond any shadow of a doubt that it pre-existed the CPK's advances into Phnom Penh. Nuon Chia does not try to hide for 1 minute that the population of Phnom Penh would have been moved into cooperatives whether or not a food crisis existed. But its decision to do so immediately and completely was driven in part by that crisis. The decision to evacuate was driven by numerous factors, which included, among others, Cambodia's long-term economic viability and short-term considerations of food supply and security. And no one factor was controlling. As we show in our brief, by the time of the evacuation, hundreds of people were dying of starvation each day in Phnom Penh. Had the population of Phnom Penh remained in the city, many thousands would very likely have died. By contrast, Nuon Chea genuinely believed that collectivization through the formation of cooperatives were essential to the production and distribution of rice. He genuinely believed that relocating the population of Phnom Penh to those cooperatives were in the best interest of the population. Under these extraordinary circumstances, the evacuation was a legitimate policy decision, and it was not sufficiently severe to constitute other inhumane act under the law as it existed in April 1975. Mr. President, I will now turn to the second overarching subject of my discussion, the alleged crimes other than the transfer itself, which may have been committed in the course of the evacuation. Your Honors, the first important point to make with regard to these alleged crimes concern the command structure in place among the soldiers who implemented the evacuation. And the co-prosecutors told us numerous times last Thursday that the soldiers were well organized and followed orders. Yet, they continue to primarily rely for this purpose on foreign journalists, in this case, John Swain, Sidney Schanberg, and Al Rockoff. All three men encountered CPK soldiers for only a few short hours on the 17th of April 1975. All three men were quickly sent to the French embassy, where they remained confined until they left Cambodia 2 weeks later. So, their observations about the discipline of the soldiers they saw in the streets of Phnom Penh are utterly irrelevant to the command structures of the CPK army. There is, however, a separate and critically important point about the command structures in Phnom Penh in April 1975. The evidence universally, unambiguously, and without contradiction shows that the soldiers who implemented the evacuation of Phnom Penh acted under the control of zone leaders and not the party center. We show you in our brief that the soldiers who appeared before the chamber testified repeatedly that during the evacuation of Phnom Penh was geographically divided into 4 distinct quadrants, with each quadrant occupied by one of the 4 zones armies which had liberated the city: the southwest, the east, north, and special zones. Some of these soldiers testified that the segregation between the zones were so strict that they were not permitted to leave the geographical space controlled by their respective units. Hein Samrin, in his statement to Ben Kiernan, explains that soldiers of one zone were arrested and detained by forces of the other zones when they strayed from their designated location. He describes negotiations between zone leaders for the release of those arrested soldiers. He even suggests that armed clashes erupted between the zone forces and that a large explosion in the north of the city was the consequence of turf wars between the zone armies. Heng Samrin was once again the deputy commander of one of the 3 divisions which comprised the East Zone Army. So he was very well placed to make these observations. And this is yet another reason why his appearance before this chamber was critically important, and why he would have been able to give this chamber crucial exculpatory evidence had he appeared for testimony. We note that our brief from last month, which the co-prosecutors were presumably responding to last Thursday, focused substantially on this critical fact. Yet the co-prosecutors chose not to say a word about it. They tell us only that the soldiers were well organized and disciplined. Even if the evidence the prosecutor cites were reliable, and it manifestly is not, the discipline of the soldiers would be entirely consistent with the fact that their orders as to implementation came ultimately from zone commanders, not the party center. So, Your Honors, we submit that the prosecutor last Thursday conceded this critical point. And as they must, because no evidence to the contrary exists. Now I turn to the specific allegations against Nuon Chea in connection with the evacuation. And there are essential 3 such allegations. The first is that Nuon Chea is guilty of political persecution against the upburn population. And as we demonstrate in our brief, the allegation rests in the assertion that the CPK saw the 17th April as political opponents. And there has been allegation of the threat of fire, but as a matter of fact, there has never been any substantial evidence. Mr. Sarkar said he has never witnessed any mistreatment of the Khmer Rouge soldiers on the evacuees. Numerous witnesses said before the Office of Investigating Judges that they witnessed no mistreatment by the Khmer Rouge soldiers on the witnesses, on the evacuees. The prosecutor said Mr. Kung Kim, the former Khmer Rouge soldier, said there was no law on the execution of evacuees in the course of evacuation, even though there have been tremendous efforts of the co-prosecutor to elicit answer from Mr. Kung Kim that they could that the soldier could kill the people. He said that once the Khmer Rouge soldier entered Phnom Penh, the soldier were not expected to kill the people. He said that, I quote, the reality is that when the people were being evacuated, if there was no exchange fire from the other opponents or soldiers, then people would not be shot at. But if there are fire among the civilians, then there would be soldiers inside and we would be ordered to shoot at them. But if they were only pure civilians, then we were not ordered to shoot them. The co-prosecutor's decision to cite the testimony of this one soldier was one of only 2 witnesses in support of their claim that CPK soldiers participating in the evacuation were instructed to use lethal force as part of the evacuation of Phnom Penh is indicative. It strongly corroborates Nuon Chia's claim that no such orders were issued from the party center. Mr. President and Your Honors, I have already dealt with the first population movement, and I would like to now address the Chamber concerning the second forced movement. I will now focus the Chamber's attention on the allegations surrounding Phase 2 of the population movement. As the Chamber is aware, in relation to the second movement, Nuon Chia faces charges of extermination, political and religious persecution, and charges of other inhumane acts through enforced disappearance, forced transfer, and attacks against human dignity. These charges are unsubstantiated. They are unfounded. For each, I will highlight the ways that the evidence advanced by the co-prosecutors is limited, vague, and misleading. By focusing on the ways the co-prosecutors are unable to establish the requisite elements for each crime, I will highlight how the co-prosecutors fail in their attempt to prove each crime beyond the requisite burden of a reasonable doubt. And I will also show how they are unable to establish a connection between Nuon Chia and any of the acts alleged to comprise the material elements of the offences charged. Before turning to each individual crime, I would first like to set the record straight regarding the responsibility for the second population movement's implementation. In their brief, the co-prosecutors claim this decision was taken by Nuon Chia and the Standing Committee. Such a claim is unjustified. Nuon Chia never ordered the second movement. In fact, he only learned of it after the zones had set it into play. Let us pause for a moment and recall that Nuon Chia has acknowledged his responsibility for the first population movement, the evacuation of Phnom Penh. Had he been responsible for the second movement's implementation, he would have acknowledged it as he has done with the first. He has no motive to lie, yet he does not admit this. He does not admit this because he was not the one responsible for the second movement's implementation. The one piece of evidence cited repeatedly by the co-prosecutors and the OCIJs in support of Party Center's supposed involvement is an alleged document of the Standing Committee that refers to the need to add 400,000 or 500,000 people to the population of the Northwest Zone and relocate an unspecified number of people to the then North Zone. But what does this document actually show? It establishes nothing more than the CPK's vague desire to increase the population in the Northwest Zone. It does not establish beyond a reasonable doubt that either Nuon Chea or the Standing Committee agreed, planned, ordered, or instigated the alleged second population movement. Instead, the fact that the decision to implement the second population movement was taken by zone leaders, not the party center, is clearly illustrated by one telegram from Chon to Pol Pot. This correspondence establishes that the zones had authority and responsibility over the movement, not the party center. It states, and I quote, "The zone was to remove 50,000 people and turn them over to the north," unquote. This responsibility is again confirmed in a September 1975 party document that indicates that 500,000 people were to be relocated to the northwest, 20,000 to Prasvihir and others to Kampong Thom in the North Zone, stating, quote, "Each zone must make appropriate preparations and not let things sway back and forth," unquote. And I repeat the quote, "Each zone must make appropriate preparations and not let things sway back and forth," unquote. I will now move on to the charge of extermination lodged against Nuon Chea. Nuon Chea cannot be found guilty on this charge. And I will tell you why. There is no evidence, let alone evidence beyond a reasonable doubt, that mass deaths occurred during the second population movement. In our brief, corrects interpreter, in their brief, the co-prosecutors are unable to point to any direct first-hand evidence in the form of witness testimony or OCIJ witness statements which proves otherwise. Their reliance on Sok Chin's testimony to establish the occurrence of deaths during the second movement is misleading. He did not witness a single death. His testimony that he buried one decomposing body located along the railroad track does not come close to establishing the occurrence of mass deaths in connection with the second evacuation. Likewise, the co-prosecutor's reliance on the testimony of Tương Sokha that, quote, "people who hid to evade the transfer were all executed," unquote, is a gross misrepresentation of her actual testimony. Read in its proper context, her testimony reveals this information was conveyed to her by a third party in 1979, after the fall of the Khmer Rouge. It is even unclear whether the source of this information observed it firsthand or whether he too heard it from others. What is clear is that Tương Sakha did not witness any death during the second transfer, and that the allegation that individuals who attempted to evade the transfer were executed is one based solely on hearsay or conjecture. The co-prosecutor claimed in their brief that numerous confirmed deaths en route during the second movement included infants, children, and the elderly person is equally disingenuous. Both the co-prosecutors and the co-investigating judges cite the same two sources for the assertion that any death occurred before or during the second population movement. Kung Vaj relates the deaths of two of her infant children from illness and lack of milk, while Denise Afonso documents the deaths of a single elderly person en route to the train to Bat Dambong. Although tragic, neither narrative comes close to establishing the occurrence of deaths on a massive scale, let alone establishing it beyond a reasonable doubt. One of the prosecutor's most despicable mischaracterizations of the facts is found in their assertion that, quote, DK commanders also killed orphan children during the course of the transfer itself, unquote. Misleading and manipulative. The use of this statement highlights the co-prosecution's desperate attempt to take one entirely unrepresentative civil party statement that addresses the brutal actions of a single unidentified squad chief and use it in an attempt to describe general condition of the second evacuation. And the co-prosecutor know that no other allegations of such behavior exist. The bad faith manner in which they have attempted to portray this statement is dishonest, and it is entirely unreflective of witness accounts of the second movement.
Contrary to these mischaracterizations, trial testimony reveals that no physical violence or torture was used against the evacuees. Numerous witnesses testified that no death occurred in the course of the second phase population movement. When questioned as to whether people were executed or tortured, witness Tương Sakha replied that she did not see any dead people at that time, and that when I was on the track, I did not see any people being killed. As evidence in our brief, CPK cadres took affirmative steps to care for evacuees when possible and provide food and basic necessities, and that the physical condition of the evacuees was stable. Lai Bune testified that from the early days of the second movement to the time period immediately after resettling, the physical health of the evacuees was normal. Although some witnesses stated that conditions during the population movement were grim, not a single witness with first-hand knowledge of events reported that these conditions resulted in death in significant numbers. Indeed, Philip Shaw testified that he had no specific knowledge as to whether the second population movement had been marred by death, let alone death rising to the level necessary for a finding of extermination. This lack of support for the charge of extermination pervades the evidence before the chamber. With no direct evidence to establish mass death, in conjunction with the second population movement, it is impossible to conclude that such a crime occurred, let alone find that any policy or intent on behalf of the CPK existed to exterminate mass numbers of evacuees. Similarly, the co-prosecutors can point to no piece of evidence to suggest that Nuon Chea or any of the cadre who implemented the movement had a specific intent to subject a large number of people to conditions of life calculated to bring about their death or intended to cause death on a massive scale. The very fact that witnesses reported significant variance in conditions during the alleged transfer proves this intent was lacking. Had conditions been calculated to bring about large-scale death, no such variations would have been reported. If conditions had been calculated to cause death, the cadres who assisted evacuees, as the evidence shows that they did, would have been acting in contravention to the orders of their superiors. Large-scale death was also inconsistent with and would have defeated the alleged purpose of the population movement to add a large workforce to areas in the northwest zones. There is also no direct evidence that the Standing Committee ever agreed, planned, ordered, or instigated to initiate the alleged population movement itself, let alone any evidence in relation to the committee's intent, in relation to the conditions of the transfer, and still less the large-scale deaths of the alleged evacuees. With no evidence presented that Nuon Chea or the Standing Committee participated in a common purpose, designed any plan, issued any order, or instigated any person to inflict conditions of life calculated to bring about the death of a large number of people, Nuon Chea must be found not guilty of this charge. Accordingly, the chamber must acquit Nuon Chea. Now, I would like to pause for a moment and focus on the attempt by the co-prosecutors to include allegations of death in cooperatives that occurred after the end of the second population movement to their calculus of the second population movement itself. These claims are outside the scope of the second movement. References to allegations of deaths of transportees after their resettling in new cooperatives concern events that happened after the second population movement. The co-prosecutors attempt to backdoor these claims into their analysis of the evidence simply shows their desperate need to bolster the evidence of the second population movement. As this evidence is outside the scope of the second population movement, it is therefore irrelevant to the charges at hand, and the chamber should give it no weight. I would now like to turn to the charge of political persecution. As I have stated just now, and we have stated in our brief, the second population movement was implemented with the purpose of shifting a much-needed workforce to the countryside. It was not, nor was it ever intended to be, a persecutory act. No evidence presented by the co-prosecutors or contained in the case file supports an alternate conclusion. Despite this, the co-prosecutors allege that the movement was one in which new people and individuals of the former Khmer Republic were specifically targeted. Misrepresenting the evidence in their brief, the co-prosecutors referenced less than a dozen witnesses who state that only new people were transferred. From this wholly underrepresented sample size, the co-prosecutors again attempt to draw another misleading conclusion that nearly all those transferred during the second evacuation were new people, and that the transfer, in and of itself, was a persecutory act towards this population. What the co-prosecutors strategically avoid in their analysis are witness statements that show that the first true population movement was comprised of both new and based people. As noted in our brief, witnesses Ms. Seun and Yim So-wan are but two witnesses who allege that the second movement was not comprised only of new people, but ultimately of new and based people. Mr. President, shall we take a break now? President, thank you, Council. The time is appropriate for a short break. We will take a 20 minutes break and we return at 3 p.m. to continue our proceeding.
សូមក្រោកឈរ